Okay, we're going to go ahead and get started. Welcome. I'm Pam Metzger. I'm the director of the Deason Criminal Justice Reform Center, and I am so incredibly happy to welcome you all to this webinar on constitutional workloads, the new resource that the Deason Center has published for public defense providers. It's been the labor of many, 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 many weeks and a lot of effort by the team, and we're very, very proud of it. So let's dig in. First of all, I just want to tell you a little bit about who you're going to be seeing today. You already know you're seeing me, but we'll be joined by Malia Brink, the Deason Center's policy director. Malia is going to be talking about the resource. Many of you know that she, along with Cynthia Lee from our office, were two of the 4 co-authors of the National Public Defense Workload Study. So she'll be leading us through the resource guide, and Dr. Lori James, the executive director of NAPD, will be doing a Q&A with Malia. So most of y'all, if you're here, you probably already know the folks on this slide anyway. So a couple of words about the Deason Center just before we kick off. I think it's pretty obvious. Right to counsel, rural justice, and maybe some of you don't know, prosecutorial discretion are our primary areas of focus. On the right to counsel, obviously, we're public defense front and center. We focus on day one representation, on defender system design, and ultimately ethical workloads. Rural justice, I want to say just a quick word. We can go back. We focus on rural legal deserts, system mapping, and state partnerships. And I want to stress here that we do have a pilot rural day one, if any of y'all are interested in checking it out. Lastly, a brief word on prosecutorial discretion. We focus almost exclusively on screening, and obviously that connects with our focus on day one work. So with that, let's get into it. Malia, if you can advance the slides. So this is just a quick overview of our work. We've been in 39 states and territories in a deep way, working with our policy team on meaningful and sustainable reform. We also have a lot of work in publications, reports, policy papers, scholarly articles, events. This is one of them, whether they're expert conversations in this context or live events on our Dallas campus. And lastly, but not least, we have a tremendous student program, both at the graduate and undergraduate level, law students, undergraduates, and graduate students in other disciplines who join us and work in these areas. So when we think about this, it's impossible to think about it without NAPD. So we were so very, very lucky to have Lori agree to join us and to help co-sponsor this event and this work. We're incredibly grateful. And as I said, you'll be hearing from Lori later. Is anyone else getting feedback, echo feedback? Somebody's in the chat saying they're getting a lot of feedback. All right, we're gonna keep on going then. I'm sorry, Lemire, that you're having a problem. I'm not sure how to help there. So we're gonna jump in. So as I said, we're very happy to have Lori and NAPD co-sponsoring with us as we talk about this incredible study and, more importantly, this toolkit that we've built for the folks on this call. Yes, policymakers, but predominantly folks in the field, public defenders. So next slide, Malia.
Nope, this is Lori. It's Lori's turn.
Oh, sorry. I thought there was one more for her. Go.
Thank you. Thank you so much. And congratulations on the launch of this toolkit. It is absolutely such an important resource for our public defender community. So I just want to first, Pam, Malia, and team say congratulations to you on the launch of the toolkit. You know, just in general, you know, this is important to NAPD because of our core mission, which is creating space for public defenders to be able to provide not only effective, but also ethical representation to the clients. And Workloads is one of the single biggest threats to their ability to do that. We know that attorneys have way too many cases, that prohibit them from seeing their clients, visiting their clients, reviewing discovery, creating effective investigations, and also being fully teamed, meaning that they have enough supportive forces around them, such as investigators and social workers and paralegals. We just don't have enough people to be able to do the work. And finally, we have the standards with the report that show us what, at least where the ballpark we should be in. The toolkit, though, provides us with the ability to use it as a resource to make the arguments, to have people to understand, to have people to be able to use the toolkit, to argue when they are seeking additional funding, seeking additional relief. And that matters to us. It matters to us because it is important that we even protect the health and well-being of the public defenders doing this work as well. They can't be the best that they can be to their clients and to themselves if they are stuffed with overwhelming caseloads. And we know that prior to the new standards being released, it had been a little over 50 years since standards had even been examined. This gives us a qualitative vision of what it should look like and what public defenders should be arguing for. It also, hopefully the toolkit will provide them with the ability to say no. We're not taking any more cases. No, we need more people. We need more funds. We need more resources. I think the quantitative approach assists, and I'm looking forward to even more qualitative approaches so that people understand the lived experiences that public defenders are dealing with, and more importantly, what their clients are dealing with as well. I'm excited to be with you today as we talk about what support public defenders still need at the legislative level. Pam, you already mentioned the issues that impact specifically rural communities, those communities that may not be rural, but may be very small and mighty, in communities in which they are working under a leadership of groups of people who don't either understand public defense, appreciate public defense, or even respect public defense. So I'm just honored to be here, and I'm thankful that we're taking time to talk about these issues.
Thanks so much, Lori. And I want to really kind of double click on what you said about the lived experience of people in the field. I haven't been there recently, but I was certainly there once upon a time and for a very long time, managing way more cases than anybody could or should. And I've been there in the field when lawyers, particularly in Orleans Parish, have said no more. And I think making sure that lawyers and the folks who are managing public defender programs are able to talk about their lived experience is incredibly important to us, which is part of why we've prepared a little video about this work. Now, I want to begin by saying it's short, first of all, and many of you are going to look at this and say, yeah, that I know already. That's my experience. But not everyone has the same experience. And we think it's incredibly important to highlight what it means for public defenders, particularly the folks who are in the field fighting this battle and saying no more.
Defenders who had sued the state, saying that they were being forced to take on too many clients.
Oklahoma public defenders are some of the most overworked in the country.
When a public defense attorney has too many cases, they can't provide every client with competent and diligent representation. But every one of those people is entitled to the effective assistance of counsel as promised by the Sixth Amendment. This is a constitutional crisis.
It took me, unfortunately, years to realize, like, if you've got over 100 felonies, nobody can provide, ethical, effective assistance. If you're intellectually honest, right, you know that, like, we're being ineffective. Okay, so you know that in your core.
You have the attorney that is going to give it their all. They're going to work around the clock. They're going to get 3 or 4 hours of sleep a night. They're going to try to be everything they possibly can that their clients deserve, and they're going to burn out. We didn't have any time to really work up cases. Which client is facing the most serious consequence or risk at this moment? That's going to get all of my attention.
And one of the things that I think I regularly see are just an incredible cadre of dedicated, client-centered, zealous lawyers who are just crushed by the weight of the work.
In 1973, the National Advisory Committee on Criminal Justice Standards and Goals issued the first public defense caseload standards. 150 felonies or 400 misdemeanors per lawyer per year. Almost immediately, the NAC standards were criticized. They didn't distinguish between a burglary and a homicide. They lacked any evidentiary basis. And because they wildly underestimated the amount of time it actually took an attorney to effectively defend.
Nobody actually knows what they were based on. Like, was there any empirical information about how long cases should take or how many cases a person can handle? And the answer seems to be no, not really. It's not about caseload, it's about workload. But there is value in having a study that takes everything that has been learned over the last couple of decades about workload and putting it all together with expertise to say, here's a revised national standard.
50 years later, the National Public Defense Workload Study set new national workload standards. Unlike the NAC standards, the NPDWS addresses the tasks and the hours needed to provide reasonably effective assistance of counsel to every client.
This study and these standards allow us to turn back and focus on our clients, right? Even more, right? Our metrics now that we're looking at is, how am I meeting my obligations to you?
This is such a light years improvement. This is the first of its kind we've had, and it's so useful.
And it was particularly important because there was this 1970s outdated national standard that everybody was using that everyone recognized was wrong.
This toolkit is exactly what the information and the guidance that the experts provided us at that time.
The thing about this tool, it provides like really strong evidence to like prove what you already knew to be true.
So that's just a little sneak peek at some of the folks who've been fighting this battle, and an overview of the ways in which the National Public Defender Workload Study is going to be helpful. So with that, I want to introduce a little bit about what this tool is and why we're holding a webinar on it. If you have questions, please go ahead and put them in the chat. We will be monitoring it. The National Public Defense Workload Study has four authors, really, the American co-producers, the American Bar Association, the National Center for State Courts, Rand Corporation, and Stephen F. Hanlon. The actual authors on it, Malia Brink, Cynthia Lee, Nick Pache, and now I've forgotten because my slide is gone. Malia's laughing at me.
Because you forgot Steve Hanlon.
Because I forgot Steve Hanlon. I know, because Steve was on the slide before and I'm like, I already covered him. Steve, you get 3 call outs. Let's go to the next slide. So one of the things that we wanted to stress here is that this National Public Defender Workload Study gives you a comprehensive history of all of the efforts that have been made to calculate workload. It also gives you an overview of the very rigorous methodology that was used to create the study and the standards. Last and certainly not least, it has become a critical resource for many of the folks you saw in this video and others in the field who are trying to think about how to say no more when the time is right. On the other hand, it's more than 160 pages. And if you're already struggling with workload or managing folks with workload, it can be really challenging to wrap your head around it. And so our thought with this tool was to try and do a couple of things that maybe were addressing what does the field need? What is it that the field needs? And our goal was to give the field step-by-step instructions, illustrations, and examples, and answers to frequently asked questions that we knew folks have had and would continue to have about the workload itself. And so you're going to hear from Malia Brink and others about that work, but I have to say first that none of this would be possible without the support of Arnold Ventures, not just in creating the National Public Defender Workload Study, but funding the time and energy it took to distill that work into something that's available, accessible, and toolkit for defenders. There's that famous Dorothy Parker line. I apologize for sending such a long letter, but I didn't have time to write a short one. We like to imagine that this toolkit is the short version of the National Public Defender Workload Study. And so with that, I'll hand it off to Malia Brink.
Thank you so much. And And I just want to reiterate, we will have time. We're going to do a Q&A with Lori after this presentation and then open it up to you all for questions. If you have questions, throw them in the chat. Cynthia Lee is monitoring them and kind of teeing them up for later. But I just get the opportunity to walk you through what we tried to do and how we tried to make this more accessible. So Pam started with the National Public Defense Workload Standards. These standards were really important, right? The difference from NAC to these standards is that these standards actually measure the attorney time required on average by 11 different case types for adult criminal court. And they got to those hours by taking into account all the tasks that lawyers do in a case, right? So thinking about how much time it takes in cases of these case types to do all of the things lawyers do, communicate with their clients, right? Review discovery and conduct independent investigations, talk to experts, do the motions practice and research, talk to prosecutors, prepare for court, go to court, and then all the sentencing, mitigation, and post-adjudication work. And that is all the component pieces that go into that standard, that time requirement for all of the different case types. Lots of groups have applied the National Public Defense Workload Standards. You know, and in the jurisdiction specific standards, you get to standards and then there's an application of them. But sadly, when we looked at kind of how to apply them, you know, all of the previous work had been like to a particular jurisdiction. And therefore, in reviewing the application, kind of it answered the questions that came up in that jurisdiction, but not the questions that might come up in other jurisdictions. Also, often because the people who had done the application had already done the work to collect the data, it didn't really talk about what the data needs were to apply the National Public Defense Workload Standards. And so one of the things that we thought was like, okay, we need a like very clear explanation of what data you need to go through this process. Often they assume that critical steps had been completed. And by those, I mean, you know, how does your criminal code map to the MPDWS case types? How do you get to a projected caseload? You're applying those standards to like your next year's caseload. How do you figure out what your next year's caseload is likely to be? And then really importantly, how many hours do your attorneys have for casework? And those are all really important component parts of an application of these standards that really had not kind of been well explained to how to get there. So that's what we set out to do. We set out to try and break this down into steps, explain all the key component parts of those steps, and just as Pam said, make this more accessible to the people in the field, the public defense providers who are trying to use these standards, but they're trying to do it in a situation of overload. So they don't have the time to read 166 pages, digest it, and kind of apply it correctly. I want to say one thing, which is that we've made this simple in its explanation. That doesn't mean the process is not complex. And so we're trying to make it simple to understand what to do. The actual doing of it will still have hurdles. And I want to be kind of forthright about that. I also want to be super honest that like right now, what the toolkit does is help providers assess attorney staffing needs for like across the organization for budget purposes, right? Understanding it across an entire provider group. While these standards are also good for monitoring individual attorney caseloads, that's not what we've explained yet, but I promise it's coming. It's just, this was kind of the first, and for a variety of reasons, kind of the use that most people associate with the standards as you see, you know, San Francisco decline cases and have to litigate that, right? This is the common context. So this was the first thing we tackled. It's not the only thing. So what is the first step, right? Let's just walk through the steps. The first thing you have to do is figure out how in your jurisdiction, your criminal code, the charges that exist, map to the National Public Defense Workload Study case types. And there are 11 of them. So you're sorting your criminal code into 11 different buckets. And that can be complex. The National Public Defense Workload Study didn't provide a single definition for its case types. It actually provided 3. Provided a descriptive definition, provided examples of charges that we thought would fit within that description, those case types, and it provided a projected sentencing range. And oftentimes, if you're in a particular jurisdiction, those things, they don't like align perfectly across every single charge. So what do you do when they conflict? And the answer is, it's a choice. It's a choice that jurisdictions have to make. And so here's an example. And one of the things that we tried to do was provide examples like this and explain how you might, when you have choices, when you need to do analysis and what those choices are. So in this jurisdiction, manufacturing an illegal narcotic is punishable by up to 20 years in prison. If we go back and look at this, what we provided here, the definition of felony, a mid-level felony case under the National Public Defense Workload Study, you will not be surprised that descriptively, this is a mid-level felony case. It's also literally an example in the mid-level felony case that says manufacturing or distributing narcotics. But that 20 years puts this in the sentencing range of a felony high other. And so confronted with that, the jurisdiction needs to decide, does this more legitimately fit within felony mid case or a felony high other case? What should this charge be mapped to? It's a choice. You have to make a choice here. There are a bunch of considerations that you should take into account. One is the likely sentence. So is that up to 20? How often does it hit above 15 if the expected sentencing range for mid is 3 to 15? How much increased work is there for the attorneys? Because at the end of the day, these case weights, the standards, they're all about attorney work. So how much work is created by that additional potential sentence? And our general recommendation, which we provide an explanation of on the site, is that absent robust evidence that these cases are routinely getting 15 to 20-year sentences, the best choice is the conservative choice. Partly because we know that this is primarily used for budgeting, and because you're walking in and having to deal with, really kind of strict reviews of this. But the best choice is a conservative choice, in part because it's the most defensible choice. This is just an example of some of the examples we provide, but it's kind of a good case, code mapping example so that you can understand how do you map your charges. The next step is you're going to put your case map to the side for a minute, and you need to use your historical caseload to estimate your projected caseload. So you got to figure out, okay, I'm doing a budget for next year. How many cases of each case type do I think I'm gonna have? This is probably the most challenging step for most public defense providers, in part because historical caseload information may not be easy to gather if you don't have a robust CMS. It may be that you just don't have access to it. But this step requires defining and counting cases in line with the National Public Defense Workload Study, meaning person cases. And if, for example, you have all of your cases listed by charge, this will be an incredibly complex step. It requires then gathering and sorting your historical caseload data, using that case map you created into the 11 case types, and then projecting a future caseload either by using just years of data or doing something more complex, averaging 3 years of data, or thinking about law changes and making adjustments to those averages. Our goal was to walk through the simplest version, recognizing that even that may be difficult for many providers, but also provide access to those more complex versions for people who do have access to more data, and give you a variety of ways to do this and do it effectively given what your situation is. One of the things that we decided to do was just create a fictional jurisdiction. I have to tell you, we went round and round about the name, and we landed on fictional jurisdiction because anything else we came up with either sounded too cute or too real. But we wanted to provide you very clear examples. So this is an imaginary statewide system. It's pretty big. And we assumed that it was developing a 2026 budget to estimate its attorney staffing needs. And we also kind of assumed that like it had a couple years of data, but that the last year's data wasn't available because that's what most people work with, right? You're developing your budget about halfway through a year. That year's data is therefore not available, so you're looking at the 3 years prior to that or the 1 year prior to that. So this is kind of our fictional jurisdiction. We were like, okay, in fictional jurisdiction, there are about over 40,000 cases. When it went through the code mapping and then went back through the highest charge for all of those cases for 2024, it came up with a set of, its strata of how those cases fit into the MPDWS case types, and then used that as its projected caseload. This is a not simple, but simple way to do it, right? Getting to here is very difficult, but getting from here to here is very simple. And so wanted to give you kind of different options. We use fictional jurisdiction throughout the site. We literally walk through every step with their consistent caseload numbers, their fictional consistent caseload numbers, to show you what that kind of results in. Once you have your projected caseload, you need to apply the standards to understand how many attorney hours you need for all the cases that you have. And you do this by case type. So you have to do it 11 times. So you take the projected caseload for a particular case type, let's say LWOP, you apply the standard of 286 hours, and you get the attorney time needed for those cases. So here's the LWOP calculation for fictional jurisdiction. You saw, if you remember on the previous slide, their projected caseload was 18 of these cases. You multiply it by the standard and you get 5,000 hours of attorney time needed for their life without parole cases. And then we walk you through each step. So you have to do that 11 times for each 11. So here's that 18 that you saw before. Here's the 286. Here's the 5,000 hours. You do it across all of the case types, and you end up with a jurisdiction that needs just under 1 million hours of attorney time to handle its caseload. Obviously, one of the things that I will say, and that I always say, is that when you do this, you get some really interesting information out of it, right? Looking at this across a jurisdiction tells you exactly how much of your attorney time is spent on, for example, major felony cases versus lower level cases. But at the end of the day, with the way things are right now in fictional jurisdiction, you have roughly 1 million hours of attorney time needed. Step 4. Now you got to translate all those hours into people. So how many actual attorneys do you need to provide all of those attorney hours? And to do that, you have to understand how many hours your attorneys have to spend on casework. And one of the things that's really important is, there's a lot of default out there on this. The ABA workload studies defaulted to 2080 hours, which is 8 hours a day, 5 days a week, 52 weeks a year. That's a lot of time. And casework is not the only thing that public defense attorneys do, right? They have administrative work, they have travel time. I really hope they have vacation and sick leave and some time off. And none of that is accounted for when you default to 2080. And while it's a very conservative choice and a very defensible choice, lots of studies have gone through the process of actually analyzing how many hours an attorney in a particular jurisdiction has for casework. And so we also walk through that process. So we walk through the process of figuring out how many days off do people have for vacation, for sick leave, for holidays. And then also, how do you measure the non-case work that attorneys have to do? How much time do they spend in training? How much time do they spend in travel? How much time do they spend in administrative work? And again, on the site, we walk through this for fictional jurisdiction. But one of the things that we also tried to do is provide real world examples where they exist. So in jurisdictions that have gone through this process, what are the resulting hours? How far off 2080 does that take you, right? And so Washington State ends up at 1650 hours. Colorado ended up closer to 1300. North Carolina ended up with a range that was between 1320 and 1375, providing you with other kind of jurisdictions to compare yourself to understand how reasonable is your assessment of where you landed. And then we're also trying on the site to not just say, here is the way to do it, but also answer frequently asked questions. And this is a big ask we have of you all. We hope that as you walk through the site, you tell us what we haven't provided you with. Tell us what answers you still need. You're going to see some places where it says coming soon because we're still working on answers. I feel like, I'm looking at Pam, that this is probably the next year of Cynthia and my time of like trying to answer questions 1 or 2 a week for a very long time to try and build this out. But how do you do this in an assigned counsel program where maybe not everybody's full time? You have a full-time public defender office. For the most part that you're starting with, one full-time person and how many hours do they have, and then the subtraction is easy. But we're trying to address it for all of the types of providers that may be out there who may be trying to do this. And then the very last step is you say, okay, this is how many attorneys I have in my system, full-time equivalent attorneys I have in my system. You subtract that from that number that you got from step 4 about how many you need, and you understand how deficient you are or not in terms of how many attorneys you need to cover the projected caseload that you've come up with. Again, understanding how many attorneys you have is another one that can sound very simple and be very complex because you have to subtract out attorneys who are not working on the caseload that you're looking at. The National Public Defense Workload Study really only addresses adult criminal. So if you have attorneys in your system who either in part or in whole are addressing juvenile delinquency or juvenile dependency or mental health cases or appeals, all of those attorneys have to come out of this assessment before you do the subtraction. And so walking through that process, walking through what to do when you're, again, not having all full-time attorneys in your system, walking through how do you subtract out for people who are supervisors, full-time supervisors or part-time supervisors, to understand what your deficit or excess is. So yeah, sorry, I should have been advancing. So current FTEs, you have to exclude your full-time administrators. You have to exclude part of your part-time administrators, right? All those other case type FTEs that we talked about, juvenile delinquency and appeals. And also sometimes new attorneys, if you have a really robust new attorney program and they spend time shadowing people, or when people move up to a specific division, they spend time shadowing, sometimes you don't count those new attorneys or new to a position attorneys as full-time attorneys. You discount it for some of the work that they do observing or shadowing in addition to maybe more intensive training. And again, we did this for fictional jurisdiction. Our fictional jurisdiction, which I have to admit is loosely based on a real jurisdiction with multipliers, so you won't be able to figure it out, was projected a deficiency of 41%. So they need a total of 630 lawyers. They have 373 and a half lawyers. So they have a pretty significant deficiency. It's not as bad as in some jurisdictions that have done this analysis where you need twice or more of the lawyers you have. But this is really significant. So Lori, having walked through the site, and you got a preview. I know we handed it to you. I didn't just say like, come up with this off the top of your head. But wanted to say, to give you a first shot at questions.
Well, thank you.
And what what you want to know more about, having reviewed the toolkit.
Thank you. I do, again, it's important that we acknowledge the hard work, Malia, of you and Cynthia and others who I don't know their names, but know that they participated in the development and Pam's commitment. I know I said that earlier, but I don't think we pause enough to celebrate hard jobs that we do. And this is amazing. And your commitment is amazing to this topic of workloads and studying workloads. And so we thank everybody for that. I also want to say I just wish I was in the room when you landed on the fictional jurisdiction name, like and the aha moment. Like, let's just land on that. Like those sort of research moments after you go around and around are like, amazing. So as we look at the website, I think one of the things I was thinking about, and you and I talked about, and you even said it, that the explanation and as you go through the steps, it may seem simple, it may seem like a simple process, but acknowledging that we all know that it doesn't mean that it really is that simple. And so, are there ways to shortcut it? Have you found that offices have used or jurisdictions have used part of the methodology along the way to make arguments, to ask for resources for whatever use they've had for it, without going through the steps, especially if they don't have the support behind them to say, take the time and do this study and see what the needs are?
Yeah. Well, so let's start with step one, because I think that's a very obvious one, right? It's complex to do the analysis charge by charge through the criminal code. If you have segments of your criminal code, you have your misdemeanors and felonies divided into category A, category B, category C. You could look across those categories and say, can I just, look across this category, and when in doubt, say this is mostly mid and maybe I need to downgrade some and make a more conservative choice, but for the bulk of this, I'm going to just move it over. In jurisdiction specific studies, that was certainly done as a way of case typing. Like I think about Indiana, where they have felony categories 1 through 6, and they use those and correspond to specific case type. I see there's actually an example in the chat where, Washington State used felony A, B, C, and then maybe like went through and looked at it and said, maybe there are a couple we need to switch, but for the bulk of them, we'll do this. That's a good shortcut. Look, there are ways to do kind of quicker, dirtier versions of this. So for example, if you have very easily accessible just felony and misdemeanor, you could do one of two things. You can just assume they're all felony low and all misdemeanor low. You're going to get a very conservative estimate of your need. But at least it would give you something in a starting place. And if it showed a significant deficiency, then emphasizing how conservative it was would be a great way of kind of starting an approach to getting more resources that is at least based on data and standards. So I think there are a variety of things you can do in that moment when you look and you say, this is what I have, what's the closest I can get. And we tried to provide some examples of that as well. The other thing you can do is try and sample. So maybe like I'm thinking about now in step 2, where you're trying to understand your historical caseload. Maybe you have your total number of cases, but you don't have them across the case types. And going through each and trying to understand the highest charge and then use a case map is very hard. These are places where if you have some support, if you have some like a research folk, you might be able to figure out how many cases you need to look at, sample them across the case types, and then use that kind of sample to generate your projected caseload. Those are things that we help with. We help jurisdictions do those sorts of things. That's why we're willing to answer the questions, and we hope. One of the things that I did not say, actually, this was terrible of me, Pam's going to kill me. There is also a part of the website that says get help. And it talks about the pieces that we have done for other jurisdictions. Those are moments when you can call us. I'm super lucky that half the people I work with are researchers. I can't sample, but I know people who can, and they are happy to help and work with jurisdictions on trying to do some of those things.
Yeah. As you were talking, I was just thinking about, yeah, we have to remind people that they need to partner with researchers to do this. And as a undergrad, begging my professor to let me take research independent study, which he said yes, and I don't even remember what I did for the class. But I passed. And now, as a person who is a researcher and actually a research geek, I also get excited when you say things like take a sample. And so getting folks to help you in those areas that you need support. And, if you don't have, some offices are lucky now to have researchers built, within their offices, or find us somebody on your team who studied research or loves research. Like, that's their gift. Maybe they don't do it full time, but that is their gift, and they become a research geek like me, and they would love to help you. So be creative and find your unlikely allies. And I bring that up to say that many of our members, I've heard them talk about the fact that when they run the numbers, or maybe they're afraid to run the numbers because they've heard of other jurisdictions who need twice as many attorneys that they already have, and they already know that that's where they're going to land. And no one's going to no one's going to give them what they need or appreciate the struggle once they do the math and they realize what the gaps are. What do you say to those folks? And I think you're a good person for this because you're boots on the ground a lot when lawsuits are filed. You've testified in some of these cases. What's moving people? What's motivating people, like Shannon and others across the country to really take a stance? What can you say to folks to say, we know it's going to be hard. We know it's a hard lift. We know you may not like the numbers when they come out, but do it anyway.
Yeah, well, I think to do it anyway is important because it's important to know how far off you are.
Yeah.
I think for a very long time, providers just accept cases. And part of it is it's, viewed as better than the alternative. People are very afraid to let people go without representation or worry about less quality representation. But over the years, as a result, public defense has become less quality representation. We have to acknowledge that. And how far are we going to let that slide in the name of, it being better than the alternative? So I do think you have to confront it. I think the numbers, just help. It helps start a path toward digging out of this very, very deep hole. And also, when you don't get the support you need from the budgeting entities or the political entities that provide the budget, then when things go too far and you have to do something like file a lawsuit, you can say, we've been saying it, and we've been saying it, and we have numbers to back us. And that, I think, is really, really important. I feel really confident testifying on behalf of public defense providers who draw lines, in part because those numbers really do reflect, the work that needs to be done. And it's painful when you go into a jurisdiction and you hear providers say, we're doing our best, which they always are, but here are the things we're not doing. And they can tell you all the things they're not doing. And that's the place that I think this really helps us get to and should be the focus of the conversation. Because at the end of the day, this is about clients getting effective representation. Correct. And public defenders being able to provide that representation in a healthy way without, dramatic cost to their health, mental health, right? This is not a job that should kill you.
That's right.
Defending the Sixth Amendment should be a job that you can do and do well.
That's right.
For an entire career. And And I think that is the point. Um, so I don't know if I answered the question, but at the end of the day, I think we have to have the conversation. You
Yeah,
can't just continue to kind of put blinders on and say we're going to keep doing the best we can with what we have.
that's right.
We've been trying to get more. This is a new tool to really kind of force the issue of trying to get more. And I feel like I will continue to devote my career to trying to help public defenders get more of those resources that they desperately need for the clients.
Thank you. Thank you, Amelia. There's a lot of hearts and hand claps going up on your comments. So I think you absolutely resonated with folks in the audience. I do want to follow up on that one piece, because if we're asking people to do it anyway, could you just give us maybe an example of what you see when you're out there? Like, what have you seen to resonate when I was an expert witness for 25 years on capital cases, and you always know when you're on the stand, you can look at somebody out there and like, oh, I just got them. Like I just pulled them in with me. Can you think of anything that when you're on that stand that you look out and you're like, oh, this resonates. They're feeling what I'm saying.
Yeah, I don't think it's hard, actually. I have to say, it's not even me so much as, getting to see the other people who testify. I got to see Shannon testify
Yeah.
in their case. And
Yes.
um, it was incredibly powerful to talk about the burden of knowing what you haven't done at the moment at which you walk into trial or stand next to someone as they plead.
Mm,
Um, Knowing maybe what you should have looked at, knowing what discovery you haven't watched or maybe even gotten, knowing the investigative steps you haven't been able to pursue,
yeah.
knowing that there are things out there that you probably should have checked before this person, and and their family are subjected to jail time.
Yeah.
And that, you know, that does resonate. I have to say, like, I have to say, one of the things that I think is very heartening about the standards is that when you talk about 286 hours, for before you put someone in jail for life without parole, like that's not insane. And when you break it down, people understand that that's not insane. You're not talking about one lawyer spending 5 years of their life on a case. Um, but you are talking about giving real appropriate due to checking that the evidence is there before somebody spends life in jail.
That's
And
right.
you get more pushback on misdemeanors. But when you start to ask the questions, like I really enjoy nuanced questions, which is like, well, do you think it's okay to just stand next to someone and plead them after 5 minutes? What would you want if it was you or your child
Right.
or your cousin?
That's right.
Um, and also the comparisons, right? The comparisons to different medical practice, right? I
Mhm.
mean, put a
Mhm.
time limit on someone diagnosing, treating, and then doing the surgery for, a relatively routine,
That's right.
cardiac aneurysm or something, right? Something that people do every day. Just go get a stent. Let's talk about the average time required. Like some of them are more complex, some of them are not, but you want your doctor to have the time they need
That's
to do it right and not be rushed at critical moments. And that's the same thing. There's still a life on the line.
that's a good point. I think some of us can remember when the standard shifted around folks demanding that doctors spent more time with them, even when you're just going for your annual physical. So that's a very good analogy there. Thank you, Malia. So when we look at the fact that when we understand that many public defenders don't have that historical caseload data, are we worried that the number of providers will get to our offices will get to step two, which requires them to gather that data and not be able to go any further?
Yeah, I am worried about that. I think there are different routes. Different jurisdictions have tried different things. Sometimes you have to go through court data. You have to make requests of your court to understand, usually they have information on the attorneys. Again, I think one of the things that I want to stress is don't wait for the data to be perfect. We had this issue in Oregon. Oregon was a contracting system. When we did the Oregon Public Defense Workload Study, we had to go through court data. It had a little checkbox for whether the lawyer was a public defense provider in Odyssey. Using that was both potentially undercounting and overcounting because it was a point in time piece. Was the public defense provider in the whole case or not, right? Maybe they were, maybe it didn't get clicked off if the person hired counsel, or we missed cases where somebody started with private counsel and then ran out of money and ended up with a public defender for the bulk of the case, but that box got checked by the clerk at the first appearance and that was a private lawyer. Don't let those flaws stop you from accessing what data you have and doing some version of this analysis.
Yeah.
Because everybody's got some data, right? The courts have some data. Your count may not be perfect, but also, again, I'm going to say, we have researchers. Come talk to us about what you do have, and let's talk about how close you can get. We are super interested in helping defense providers build out their data capacity and use it better. I'm sure that if I could unmute him, Dr. Andy Davies is cheering this. He wants these phone calls. Nothing gives him more joy in life than helping people to understand the data they have, get to a good analysis. Does not have to be perfect. And I think that's kind of the most important message I would deliver on that front.
Thank you, Millie. I just have maybe one or two questions, and I'm going to turn it over to Cynthia to moderate questions from the audience. I just want to remind folks to use the Q&A function so that your questions don't get lost in the chat.
Just throw it in chat.
Yeah, the chat is okay?
Yes.
Absolutely. Okay, all right. So the website looks more helpful for supervisors and directors and chiefs than line attorneys. I also feel like just in general, we tend to focus the attention on those high level positions to make the change. But it also obviously adds value the more you can get the team behind, making these assessments and making these arguments and on board with you and being your backup voice. So is there something there for the line attorneys and others in the office for the toolkit?
Right. So again, like I said in the presentation, we chose initially to say, what is the overall provider need? That was for a couple of reasons. One, it's kind of the primary use of the standards, figuring out your budgeting and staffing needs. It's a projection tool. But it's also because the individual standards are averages. And averages are always kind of at their best when you are using them across bigger and bigger numbers of cases. So 41,000 cases is going to get you a more accurate result than when you're looking at an individual lawyer's, hopefully 85 to less cases, depending on the type of cases that they're doing a year. So part of it was like, let's start there because it's the easiest and it's kind of the most accurate. But we are planning to develop those tools. They come with more caveats because they're smaller. They're very good for monitoring and assessing and thinking about distribution of cases. And we are actively working on it. We're thinking about different things to continue to add. This is an important first launch, but not the end of the road.
Awesome. That's awesome. All right, my final question, then I am going to turn it over to Cynthia to moderate the questions from the audience. Right now, the website talks about building budgets and budget advocacy, but doesn't provide a lot of instruction on the advocacy part. Are you planning to build out more on the website that helps center the conversations of advocacy and solution?
Yeah. So one of the things that we did in the Get Help section was start to put up like some testimony and pieces, and we'd love to work with providers to build that out a little more on what they have found useful and helpful. But at the end of the day, our goal is to provide the assessment. You are also, I'm going to let Pam talk about it later, but there is also forthcoming a page about just data for defenders, using data in advocacy. And that is going to be even broader than workload alone. But obviously, given what we do, a lot of the examples will be around workload. And that will be a forum for that kind of tool development as well.
Awesome. Awesome. Thank you for having the conversation with me, Malia. Thank you for inviting me and, more importantly, NAPD to be a part of the conversation. I'll stick around, but I'm going to turn it over to Cynthia to moderate questions from the audience. It's good talking to you.
Yes. Thank you so much, Lori.
Thanks, Lori, and thanks, Malia, for that introduction to the website. I want to start with a very specific question about the content on the website. We had a question about, are there any graphics for understanding the calculation of the annual hours per FTE on the website?
Yes. Yes, there are. So we didn't, yeah, I'm sorry. I stepped through, like, I wanted to give an example of an example and an example of a calculation, but not every single one. So I see that somebody is helpfully sharing the website. And if they scroll down, there is like the generic version, and then there's the ABA version, and then you will see magically appearing kind of any minute the step-by-step calculation. Oh, Scott, somebody put the website in the chat because Scott doesn't know how to find the magical website. It was in an email that got sent to you before this, but it's okay, Scott. We'll put it in the chat. But yes, we walk you through, again, for fictional jurisdiction, each one of these calculations in a step-by-step format. So hopefully that is helpful. And, if you are stymied by some aspect of it, give us a call. You can see all the examples that we provided under each step. And then here is the complete, well, actually not quite complete because the total's below. Fictional jurisdiction calculation. They landed at 1586, which was something close to Washington State, and something close to where Oregon landed.
Great. So our next question is more about a more general question about NPDWS. Can you use the projected hours for each case type, the case weights, to develop caseload caps for MAC or panel attorneys?
Yes, sure. And that's something that we can address. We're actually kind of thinking about other uses. We're thinking about a section that actually helps you kind of understand how to measure the impact of legal changes, for example. You wouldn't necessarily set that at just like the 1.0 cap for reasons that we will explain on the website. But yes, it is done and can be done using those standards. And that's a really good point. We're kind of keeping track of everything that people want to know about as we both not just prioritize what to build and publish next, but also the order.
Another more general question about the standards. Can we talk about the assumptions that the NPDWS makes about support staff levels and the impact of support staff levels on the need for attorneys?
So the NPDWS is actually different from some of the state-specific jurisdiction workload standards in that in some of the jurisdiction-specific workload standards, they were asked to assume adequate support staffing. That was not true in the National Public Defense Workload Study. We actually asked the participants to assume their current levels of support staffing because it was just a level of kind of extrapolation and thinking that proved difficult. And since everybody has a little bit of, almost everybody has too few support staff across the various categories. We thought we could get to consensus despite that kind of real world assumption, and that was successful. So one of the things that has happened in the aftermath of the National Public Defense Workload Study is that some of the applications have actually posited, like if you increase support staff and took out of the attorney case weight some of the work that paraprofessionals could do, what would that impact be? There's actually a very good version of that analysis in Oregon. The Oregon 6-year plan which, I consulted on from Deason, was, did that analysis, across the different case types. But so that's a little different than if this person who's asking is coming from a jurisdiction that did a kind of jurisdiction specific workload study. It's actually a little different, than some of the jurisdiction specific studies.
Great. Another question is, has anyone attempted or is anyone contemplating a caseload study for civil commitment or guardianship? I have one answer for that. In the 2019 North Carolina Public Defense Workload Assessment, they actually did create a case weight for involuntary commitments. That study used a different methodology than the RAND study that tends to come out with a lower time estimate. Just because of the methodology that they used, but that is available. And I know Malia knows what else might be out there.
Yeah, so again, this is one where you'd look back across the now about 19 jurisdiction specific studies, and ask yourself, where are their case weights? I actually don't know the civil commitment answer off the top of my head. I think Colorado had a number, but some of them did address it. For all of the case types that are not addressed by the National Public Defense Workload Study, when other jurisdictions are doing an application, there's either a choice to do the jurisdiction specific study, which is time consuming, but a very tailored way to approach it, or you can try and adapt weights from a different jurisdiction that has done that specific study. So a number of jurisdictions have done juvenile delinquency, a number of jurisdictions have done appeals, a number of jurisdictions have done dependency. There's kind of an analysis you could do before you try to adapt one of those, or adopt it in your jurisdiction. And there are different studies that have done some of that. Particularly recently, they do an application of the National Public Defense Workload Study for adult criminal, but then use, maybe New Mexico's juvenile delinquency piece, depending on what the process and kind of the case typing and how well it matches.
We also had a question about whether the NPDWS looked at prosecutor or court workload standards.
Right. Well, you'd be better answering the court piece, but prosecutors have actually been behind the 8 ball on this. They don't have nearly as many studies as defenders. Courts, on the other hand, have been doing this for longer, and there are a number of court studies, but the RAND study did not. It was public defense standards, and the people involved, the panel involved, the studies that it studied all looked at public defense standards from other jurisdictions, and the people involved were all criminal defense attorneys across the country. And so a blunt way of putting it is no prosecutors or judges were involved in the creation of these standards, other than with the criminal justice standards for the defense that they referred to, where prosecutors and defenders were involved in the adoption of those kind of standards. But that's very important. Those studies are very different. Cynthia, you may recall this. We got a call from a prosecutor's office that said, we're applying the NPDWS standards to assess our workload. And we each had a separate reaction, as we are often do. We wrote separately our response and then compared them, so that we don't influence each other, which is, kind of a working style that we've cultivated. Methodologically, it makes no sense. There are reasons policy-wise that I think prosecution is a policy decision that it makes no sense. So applying these to try and ascertain whether prosecutors' offices are appropriately staffed is a gross misuse of the NPDWS standards.
And going the other way, why would we not want to incorporate, say, there have been a ton of judicial workload studies. I should know, I did a lot of them. Why would we not want to incorporate either the perspective of judges or the numbers from the judicial workload studies into a public defender workload study?
Right. Well, one, I don't pretend to know what judges do all the time, in terms of like there's what they do in court and there's what they do not in court. And the what they do not in court is very, very different than what public defense providers do not in court, what attorneys do not in court. And one of the things that I think was really important is if the judicial perspective on public defense work comes primarily from the courtroom, which it inevitably does. If you look at the jurisdiction-specific studies, court time makes up a relatively small component of all of the time that public defense providers have to do attorneys have to, all the work they have to do on a case. So including someone whose perspective on the work is 10, 20% of the total work would be really limited. And then on the prosecutor side, it's just, again, it's not the same work. I mean, at the end of the day, it's not the same work. Victims are not the same as clients. They're picking up cases from police and other investigative entities, and that's very different than in terms of the level of investigation that they conduct and have to conduct than what public defense providers do. Looking for probable cause is different from trying to poke holes in a case. There are just endless ways in which this work is just sufficiently different. I always like when people ask why prosecutors weren't included in setting the standards. I would love to do a prosecutor study and invite the defense providers in and see how they react. I suspect they would have the same reaction. The work is very different. And at the end of the day, that's why that's the correct answer.
Just a reminder to everyone, if you have questions, please go ahead and add them right to the chat, and we will just kind of prioritize them from there. We also had a question, Malia, about applying the standards to monitoring individual attorney workload. So can you talk a little bit about how that's different from applying the standards at the system or the office level, and also maybe talk about our plans to provide some more resources on that topic in the future?
Sure. And so monitoring individual workload gets you into a bunch of different areas that can be problematic and very different from trying to assess kind of attorney needs across an entire caseload for a provider. One of them is that a lot of times when attorneys are talking about monitoring their caseload, they're talking about open caseload and not their annual new assignments. And that is a very different application of the standards. It's not impossible, but it's more complex. It involves thinking about time to disposition, which is something that defense work itself can influence and makes kind of bringing that in difficult. And then there's the piece that I said before, which is to the extent that the standards themselves are based on an average of a case type and an average amount of time needs, the smaller the universe that you're looking at, the least likely they are to be perfectly, to be well accurate. And so when you're talking about an individual caseload and assignments, you have to bring in some externalities in terms of the person, the level of complexity of those cases, and different pieces. And so we want to do it justice. And so we want to talk about it. We want to talk about how you might structure assignments accordingly. We want to talk about open caseload versus annual new assignments. But that's going to take some work. And explaining it is again, you're trying to not remove the complexity, but also make it accessible. It's going to take a little bit of time.
So we've also had a request for a tour of the site in more detail, just so we can see more of those really helpful graphics. Do you want to walk us through, and maybe we can,
yeah,
person
let's
who's
do
driving
it.
Can pull it up?
Yes, I'm gonna say go. I'm gonna let Divya pull up the site and share again and start from the main page, and we will just walk you a little bit through the site itself. All right, so here we have the main page, which we start with why do this at all? Which is just trying to meet ethical and constitutional obligations, and trying to figure out how many cases are too many cases. And so that is why we do the work. And then if you scroll down, we're going to walk you through the standards and get you to those 5 steps, each of which are clickable. So you can click on this and it's going to take you to step 1, and talk about the process of mapping these charges. You'll see, like, it talks about how the National Public Defense Workload Study had those 3 definitions. If you want to pop one of those open, you'll see we're going to give you those definitions right on the page, and then give you some examples about what to do when they don't align. You heard me talk about making a conservative choice when it comes to charge mapping, and we explain that. And then we have some answers to some frequently asked questions, and you can pop one of those open and just give kind of an example of, we don't have the data for how often they pursue life without parole in murder cases. How do we do this? But, and we really want to show the difference between our murder cases and our LWOP cases. What can we do? And again, this is one that talks about sampling and says, when in doubt, maybe our researchers can offer some assistance. That's a call you get. And then, yeah, at the bottom of every page, you have a choice. You can go back to the main page. You can go to the next step. If you want to continue to step 2, I won't walk through the whole thing, but you can see, pause right there for a second. This step has different component parts. It has a little sitemap right there that will jump you to those component parts, and let you kind of walk through what caseload are you, whoops, something went wrong. We'll fix that. What caseload are you using? How do you gather your historical caseload data? How do you then sort those into the case types? And again, examples of counting cases, talking about in what year you count cases, trying to answer all the questions you might have when you're on this point in your journey. There's our introduction of fictional jurisdiction with its 1 year of cases. And again, I said during the component that there are times when we say, okay, here's a simple way to do something. If you're interested in the more complex way, here's an option. And so this is one of those where we said you can map 1 year of data and use that as your projected caseload. If you're worried for some reason that year was anomalous, or you want to use 3 years, or you want to try and get more fancy, maybe even use statistical modeling. If you click on explore more advanced ways, we describe the different advanced ways to project a caseload. And this gives providers options based on kind of where they are with their data. All right. I think we can pause this because I think people will go explore. I hope people will go explore the site in more detail and with more time.
More have come in actually while you were giving the tour. One is a question about RJA cases, which I assume, please correct me if I'm wrong, is Racial Justice Act.
Justice Act. Yeah.
So I assume that's a California question.
That's what I'm guessing.
Okay, so yes, there are different things that might influence case typing and in different jurisdictions. And the Racial Justice Act in California is a perfect example. Depending on what the person is talking about, whether their individual case has a Racial Justice Act issue in the, initial litigation, initial trial, or whether they are talking about challenging a prior conviction based on the Racial Justice Act. The latter would probably be its own case type, for which you almost inevitably need a California specific, perhaps several case types. to get standards. But the fact of a California case with a Racial Justice Act issue might lead to, like, that would be a case that would probably come in on the higher end of average, right? That might be an up outlier in any given case type. But I don't think that the Racial Justice Act would preclude you from using the National Public Defense Workload Study in California. I don't know if that's the full nature of the question, and I'm happy to talk more offline about it.
Another question that's come in is, how do you apply the standards to public defenders who also carry a caseload that isn't covered by NPDWS, for which the system does not have a case weight, like juvenile cases or parent rec?
So to calculate attorney need for adult criminal cases, we actually talk about this on the site, excluding either full FTE or parts of FTE for cases that are not covered. If you're talking about monitoring it in an individual workload, that is a still to come piece, and probably a frequently asked question in kind of that still to come piece. It's a more complex answer, but you would do it the same way you monitor an individual workload. You would just need some standards for the case types that they address. And so when I talked about possibly adapting or adopting a jurisdiction-specific study that addressed it under similar kind of conditions and circumstances would be one way to go. But that's probably beyond the scope. And I don't want to scare Pam too much about how much of this still has to be built.
And I know Pam
Can't
has
scare me.
questions she wants to ask you too. So I'm
Yeah,
going to
you can't scare me. At least not so far.
Actually, or not more than I already have.
Not more than you already have. Not more than some of the people who are on this Zoom already have scared me. And that's people in the audience, they know who they are. Malia, can you talk a little bit more broadly about what kind of services we can offer at the center? I mean, like kind of what our capacity is, because we do have kind of a wide range of ways in which we can support people in this work.
Right. So we have supported people by helping walk through or just answer questions as they go through their process of applying it. We have worked with them on how to kind of turn that into advocacy. We've testified at budget hearings. And I think one of those testimonies is actually on the Get Help portion of the website. People know that I've testified as an expert witness in 3 litigations this year over kind of different aspects of workload. So it's a menu. Sometimes it's just helping pull data and translate it into something more useful in budget advocacy. Sometimes it's much more in depth. Sometimes it's answering a one-off question about, I have this weird, enhancement. What do I do with it in terms of case typing? And we try and do as much of it as we possibly can, given the limitations of hours in the day, with which public defenders are very familiar. But it spans kind of across that very wide landscape.
Yeah. And I want to flag here, because particularly because Cynthia's on screen with us right now, we have folks who actually can do the work with you or for you of doing this. If you're looking at it and by some miracle you have the resources to be able to maybe pull some of this data together, but not all of it. We have a data team that's capable of doing a workload analysis. For those of you who, I don't know if Travis is on there, he was earlier. For those of you who may have been in a litigation posture, we do have litigators on our team. And as you may have noticed from this website, we have an amazing team of graphic designers and presenters who are really skilled at telling stories. And sometimes half the battle with this is translating it, not from the numbers that public defenders know, but translating it to non-public defender speak. And we can be helpful with that too. And we're really very eager to hear from y'all how else we can help in that regard. Malia, the other question I wanted to ask you about is What is the thing that you think is the biggest barrier that you see people just kind of, they feel in their guts? Everybody knows that feeling. They feel in their gut their workload is too heavy. But they don't start this inquiry. What's the barrier and how do we get over it?
Well, I think there are two barriers. One is if they feel in their gut, then they probably are overloaded, which means they have more work, which means the prospect of going down this path and adding this work to their plate is very intimidating. I think that's one of the reasons that we have built this out and tried to be so supportive and offer help to the field in applying it and trying to actually help people who really need it apply it. Because sometimes the people who have the resources and the time and the ability and the data are actually kind of the not the people who need it the most. So there's that. And the other thing is fear. I mean, it's terrifying if you are a provider who's concerned about the level of services that you are able to provide under your circumstances, to then find out that your deficiency is really you need 2 lawyers for everyone. You've been asking your attorneys to do more work than they can handle. You don't know how you're going to kind of try and bridge that gap. That's scary. The thing I would say is this is a whole community of people that's in it with you. That's why we're in it. That's why NAPD is in it. You do not have to face that fear alone. I can't make it not scary, but we can all stand there together. And honestly, it's really important to do that because until and unless more providers start this process, face that fear, try and seek the resources that are actually needed, it makes it hard for the rest of the field to do it, right? And that's the reality. So we need more and more people doing it, more and more people pushing for the resources they actually need, more and more people talking about the work that actually has to be done in cases.
And I think that the bottom line for us as a team is we're incredible. I mean, I will say I am so incredibly proud of the work that particularly Malia, Cynthia, and Jamal and Divya, who you can't see, but who are our marketing and communications team and our graphic design folks at InfoNewt have done a spectacular job. I'm so proud of this work. There is more to come here. And we are not stopping. This is a first in. Malia, I can see you getting ready to say something.
I was getting ready to share more about what's to come.
Great.
Because I
All
think
right, so let's do it.
Let's end on a high, which is that we are committed and we're still in it and we're going to do more.
Yep.
And that includes talking about other expressions of the National Public Defense Workload Standards. So this didn't actually come up, but a lot of jurisdictions like to use kind of weighted comparative caseload. So, ones and 1.2 and 1.4, and how do you do that? That's actually what is kind of in play in Washington State. Other uses, we talked a little bit about this. This is the part where we're going to try and address how to use this to monitor individual attorney caseloads, how to use it in a court-appointed counsel and other programs to distribute cases across staffing in a fair and equitable way. And also to address the impact of law changes. So you have a sentencing change that moves a group of cases from one case type to the next. How do you actually go into your legislature and say, this is what this means for us? This is the additional staffing we need. Individual attorney workloads, assessing legal changes. And then, as I said, the place that the field can help is we're trying to provide answers to more frequently asked questions as you go through the site. If there's something that you need to know, let us know and we'll add it to the queue of things that we try and answer and present. This is just on the workload site. This is not all of the work that Deason is doing. So Pam, this is all you.
Yeah, so let me talk about this. Malia alluded to this. We have a couple of new online resources coming. I'm not promising they're coming quickly, but they're coming, including our Data for Defenders page. And I wanted to highlight that one because this page is going to do a couple of things. Yes, it's going to talk about what data defenders need, but folks have already done that. What we think is particularly valuable is to talk about how to get from knowing what you need to gathering it and using it effectively. And we like to think about the kind of questions defenders are going to answer. The three main ones tend to be, How much? That's part of what Workload answers. How much work are you doing? How much does it cost? Of what kind? You know, how many trials? How many motions? How many hours of jail visits? How many hours of wait time for jail visits? And lastly, what outcomes are we getting for clients, for clients' lives? These are the questions that matter to defenders. And often these are the questions that matter in terms of defenders' ability to tell the stories that bring them resources. And so, as you can see, we do have great folks working on graphics and storytelling, and we're building out a toolkit to help you in the field figure out what data do I have? How can I marshal it? What can I do with it, even if it isn't perfect? So that's very important for us. We also have a webinar coming up that I want to highlight for y'all. Oh, I guess not. I'm going to wait. This is fancier than I knew. Didn't I tell you we had great people? They've outsmarted me.
I'm so
Look at
sorry.
that.
No, this was me being behind you. I apologize.
That's okay. I forgive you. In any event, we have another webinar coming, front loading the facts. And this is about a randomized controlled trial that we did in a DA's office. And y'all may be wondering why we're talking about that. I'm going to tell you. One of the best ways to reduce workloads is to reduce the number of cases that prosecutors are accepting and prosecuting, and to do it early, not late. So we had the exceptional opportunity to work with the Dallas County District Attorney's Office and see if we could improve the amount of time it took them to screen cases in the assault unit. We were able to randomize the intervention we proposed. I won't give it all away, but I will say this. We were able to substantially increase the number of cases they declined and the time it took them to do it. And so if you're interested in understanding what early information and providing early information to prosecutors can do in terms of helping manage workload, not just for you, but the selling point, you can sell it to your system. Tune in for our webinar Wednesday, September 2nd. You'll see a link right there. The last thing I want to stress, and maybe this is the one that Divya and our comms team would like me to stress the most, is you don't have to wait for us to hold a webinar to find out more. Among other things, you can subscribe to our newsletter. There should be a link coming up here in a minute for y'all where you can do it. The newsletter is going to give you regular information about upcoming events, new resources that we're releasing, new opportunities to get support from our team, opportunities, even if it's not in Workload, for us to come talk to you about building a pilot. I think Andre Degree is still here. Opportunities for us to come testify to help you with your research and evaluation work. We are here for you. And so I guess I want to end by saying this: you're not in this alone. And we are only a small fraction at the Deason Center. We're only a small fraction of the folks out there in the world who have your backs. But I promise you, we've got your back. Many of us have been public defenders. Others have done nothing but work in public defense and research all their lives, do civil rights work in public defense. But beginning, middle, and end, we're built for public defenders. We're here for you. We're here for your clients. Please reach out. That's why we're here. So thank you all for coming, and we appreciate the work you do. Go be strong.